prima facie. We want to assist our audiences. When we say prima facie, are we at this point trying to establish whether the accused has a case to answer? Is that what we are trying to do?
That is the point. Has he got any case to answer at all? That's prima facie.
So if that is correct, help us appreciate this. You've done many years of practice, including in criminal practice. Like we do in the committal proceedings. When is the accused invited to answer a case?
You mean when it is an indictment?
Correct.
When the case is on indictment. It's only after you have finished with the preliminary issues that you decide whether or not there is a prima facie case.
So the prima facie,
the circuit, the lower court will have to go through that process to determine whether there is a prima facie case or not.
Right. So that's a question I want to know from you. If you apply that principle, should the petition is against be called to give an opinion or response before the prima facie determination is done?
I think in both the J-Trum and the Tiger Eye, what they are saying is that whenever you do some prima facie evidence, because you are going to investigate whether there is prima facie or not, remember that all the evidence of the statements and whatever it is in the indictable matter are put before the magistrate or the circuit court, especially the magistrate, to look at. So there will be evidence before them. Statements, whatever it is, to form that prima facie case to decide whether or not the case should go to trial. Isn't it?
Yes.
So if you have not heard anything, if you have nothing from the other side,
right,
what are you determining? Well, how could you come to a conclusion that you think there is prima facie matter to go to trial?
Okay. So, like the example I gave, I want us to use that to see if we can help properly people understand. At the magistrate court, if you are doing the committal, the authorities are clear that once the magistrate finds that there is a scintilla of evidence, even without hearing the other side, they must commit. That's the authority established.
I'm saying that in that case, there's something before the magistrate, isn't it?
What is before the magistrate at this point?
The statements and whatever it is of everybody involved in determining, the prosecution witnesses, whatever. You have a whole a bill of indictment, which is telling you where you are. And is the accused statement not part of the bill of indictment?
Correct.
Yes, you have everything before you. In this case, why do you want to deny the Chief Justice whose conduct you are going to determine the opportunity to tell you in reaction to some of the things you have to enable you decide whether or not the thing itself is frivolous? Because it's a very good position to adopt, in the sense that otherwise everybody can file, and these were all discussed in the J-Trum, that anybody can just get up to file a petition against the Chief Justice. And in fact, the worst part is why it is said that where a petition has been referred to the committee under this article, the President may, in the case of Chief Justice, acting according to the advice of the council by warrant, signed by suspend the Chief Justice.
Yeah, before we get there, again, so the trial matter, the criminal process I'm trying to use as an example. I'll ask one or two more questions on that briefly so that we can proceed. You can charge an accused to court without a statement from them. Is that correct?
Yes.
Okay. And when we say prima facie in law, when lawyers say prima facie, and even when the law itself, like if you took the Copyright Act or intellectual property, they say registration is prima facie evidence of ownership, correct?
Yes.
Do you need to investigate before you can say it is prima facie evidence of ownership?
The point I would like to make to you is that so long as these matters have gone before the Supreme Court, which have received interpretation, I do not think that we should go on the general, but rather zoom in on what we know. That Ajay has made that point, that it is not fair to try and determine a prima facie case without giving the person a hearing.
Ajay as a ratio, as an orbiter. Utaderi as an orbiter or as a ratio?
Orbiter. Whether it is orbiter or ratio, they make good points.
Ajay Bafo here tells me that it was orbiter and not ratio.
Matter. For me, it does not matter.
No, we are educating our people too. What do we follow? When we say the Supreme Court has done something and it is binding, what is binding? Is it ratio or orbiter?
Well, as a lawyer, you will say that it should be the ratio decidendi of the matter.
Exactly. Orbiter is not binding.
Lawyers. But I'm saying that when the Supreme Court, the highest court of the land, has given a direction, then let us look at it this way, because it's only fair. It is only fair to the person. I don't think we should ignore it completely.
Okay.
To say that was not what the case decided, so just forget about it.
Okay.